is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation as a Class A misdemeanor.
Yes.
The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000. 23 CR 3544, State of Texas versus Garland Green. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Robert Geary, Your Honor, for defendant Garland Green, and we're ready.
Are you Mr. Green?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Green, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on the lesser included charge of assault, bodily injury, married, cohabitation.
Any objection?
No objection from defense, Your Honor.
All right, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation as a Class A misdemeanor?
Yes.
The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your
Do you
Honor.
believe he's currently competent and was legally sane at the time of the offense?
I believe that he is and he was, Your Honor.
Mr. Green, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, married, cohabitation. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge, there have not.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be no contact with Jesse Willard, JESSIE, WHEELER, the BIPP program, and anger management. Did you understand those were conditions that the state is recommending and the court does not have to follow that?
Yes, ma'am.
Then to the lesser included offense of assault, bodily injury, married, cohabitation. How do you plead? Guilty, not guilty, or no contest? State any evidence?
The state offers State's Exhibit 1 in all of its attachments.
Defense is reviewed, Judge. We have no objection.
And state, have you talked to the complainant?
We have previously, Your Honor, in complete candor, the complaining witness has signed an affidavit of non-prosecution and was uncooperative with our case.
All right, thank you. You may be excused.
Thank you, Your Honor.
All right, Mr. Green, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements or police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. In regard to the no contact order with Jesse Wheeler, the parties are cohabitating. They do share a 5-year-old son who just started school yesterday. My client works at Pepsi during the day. Mother works for Rackspace at night. So the no contact order would impose an unduly burden on the parties in respect to parenting this child. As is usually the case, Your Honor, in these situations, CPS was involved as per family-based service plan. The parties went to counseling. My client went to counseling and is continuing to go to counseling. Both parties have been and are attending marriage counseling at this time. My client says that it's been a good influence on both them and their relationship. And they feel that the no contact order, if implemented, as mentioned, would be a burden not only on their relationship, on their status, but their ability to parent the 5-year-old child. So we respectfully request that the court not order a no contact order. Thank you.
All right, so is this a son or a daughter? Because I was reading the report, it was a daughter.
Little girl.
Sorry.
Okay, no problem. I want to make sure I have it right. So what family members do you have in Bexar County?
I have my mom, my dad, but my dad, he doesn't really help out much. My mom, she really can't because she can barely move around herself. Oh, I'm sorry. My dad, he doesn't really help. And my mom, she can't because she physically can't move around to help watch my 5-year-old.
All right, so here's the thing. I'm not going to do a no harmful or injurious contact. If there wants to be a no contact order, then the complainant can appear by Zoom or even in person. I want you to understand something.
Yes, ma'am.
I read the police report, and in the police report, you said she was pushing your buttons, you're pushing her buttons, and you can unfold your arms. And all of you all were acting not as adults. Y'all were acting like children. And the child at the time was 4 years old. You all caused drama and trauma to a 4-year-old. What is a 4-year-old supposed to think? And you and the complainant are going through the apartment, throwing things around. And you tell a 4-year-old, don't throw that, place it back where it's supposed to be, and trying to lay down the law to a 4-year-old. And you all are acting worse than the 4-year-old.
Yes, ma'am.
And that's a memory that 4-year-old is going to have forever. No amount of counseling that you all go to try to put your life together is going to take away that the 4-year-old witnessed all of this drama in their life. So if he wants to have contact with the mom and they're working things out, she needs to appear by Zoom and the court will consider it. If you want to get her to Zoom in here today, then I'll consider it today. Is she able to Zoom today?
She sleep because she works at night.
Oh, well, if somebody wants to call her and have her Zoom in.
I can call her. Try
All
to
right.
call her.
So it's going to be 2 years deferred adjudication, affirmative finding of family violence, no contact with Jessie Wheeler. Of course, if you call her and she Zooms in today, I'll reconsider. The BIPP course, 80 hours community service restitution. I'm going to order parenting classes. If you've done parenting classes through CPS, that will be acceptable. If you have not, then you'll need to do parenting classes. If he's completed parenting classes related to this incident through CPS, then the community service hours will be deemed to be satisfied. There's to be anger management. There's to be CPS compliance. It sounds like it's a safety plan. So whatever the safety plan is giving them, just make sure he's doing that. And probation, if what he's doing for his CPS safety plans coincides with what I'm requesting, then the CPS, what they're doing will be enough. There's going to be regular reporting by Zoom or in person, regular UAs, and field visits one time. Well, field visits, I want at least 3 field visits throughout the entirety of his probation. So you only have to do 3. If you deem that there's something that's an issue, then of course you can do more, but a total of 3 field visits throughout his probation. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else you need? Jessie, Jessie, Wheeler, Wheeler. That may not stand if he's able to get her to Zoom in. Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. Here's the thing. When there is violence in a home, children learn how to behave, right? So if somebody wins an argument by being violent, guess what? A child realizes, hey, if I want to win an argument, I need to be violent. Or here's the thing, you have a daughter. A daughter will think that you love her mom, right? You love her. So a daughter will begin to think, oh, this is how somebody who loves you shows that they love you. They're abusive. And then your daughter goes out in the world, and if she ends up with, as my professor in high school would say, and I say professor because he was a doctor who taught us physics, he would always say, girls, do not end up with a joker. So your daughter may end up with a joker. Don't let her be the reason she ends up with a joker. And he would give instruction to the guys too. So you've got to do better. You understand?
I understand.
All right. Thank you.
Thank you, Judge.
You're welcome. 7-3, State of Texas versus Amanda Lawson. Can I have parties announced for the record? For the state,
Jason Jarrett, Your Honor.
defense,
Ray Lopez, Your Honor.
and are you Amanda Lawson?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Amanda Nicole Lawson who was placed on deferred adjudication in 2019 CR 8173 for the offense of unauthorized use of a vehicle on November 14th, 2019 for a period of 4 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 5 in Burke County, Texas. The defendant Amanda Nicole Lawson, who did in there fail to report the supervision officer as directed for the month of October 2022.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated condition.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Stand that, but I'm in hopes that you'll hear me out.
No, my question is, did you understand that? Knowing that, do you still wish to plead true to violation of condition number 5? I'm sorry?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there proposed agreement?
No, there's not, Your Honor.
State, what are you requesting?
Revocation, Your Honor.
Defense.
We're going to question that should be placed back on probation, and my client would like to testify to give a reason to report.
All right, if you can raise your right hand, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Amanda Lawson.
All right, and what would you like to say?
Miss Boyd, because you gave me a second chance 2 years ago, I went to Grace House and I changed my life. I've been sober for 2 years. I was released from Grace House because I had a surgery and I had to go home and take care of my family. I've been doing nothing but going to work and going home. I was scared. I understand that being on the run for 2 years is bad, but I was scared that I was about to lose everything that I just worked really hard for because of the way it changed my life. And I'm just hoping that you'll believe in me one more time.
All right, this is your second motion to revoke. And what I do know is that each time when persons appear before me, I ask them if there's anything that the court can do. Do they need anything so that they can be successful? And I know that I tell people, if there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to court. So you've been here before. You were placed on probation in 2019. And then you came back in 2021 and you pled true to a violation of condition number 1, which is a new offense. And then the court altered and amended your conditions and continued you. And then now we're here and nobody has seen you since 2022.
I'm scared. I was at home. I was taking care of my family.
Why don't you pick up the phone and call probation?
I was scared. I can't have no excuse for that, Miss Boyd.
Okay.
I was scared to lose everything I've just worked so hard for. My grandma is 75 and my grandpa is 95, and I have my kids back in my life. I have a relationship with them now. I've been sober since Grace House. I haven't worked so hard for something. It would just destroy me to lose it again and start over.
All right. So these are choices you made.
Yes, I understand that.
You made the choice not to report.
I understand that. I'm just hoping you'll believe in me one last time.
All right. Any questions?
She said all.
Any questions?
No, Your Honor.
All right. The court is going to grant the motion. The court is finding you guilty. Does anyone want to speak with regards to punishment? State?
Yes, Your Honor, the state's requesting 16 months state jail.
Yeah, we're requesting the minimum. He has 166 days in. We also have some credit for the time she served. And
All right. So what I can tell you, Ms. Lawson, the state is requesting 16 months. I had internalized everything you said. And actually, what the court was going to do was sentence you to 2 years in the state jail facility. But the state is requesting 16 months. So I'm going to sentence you to 16 months in the state jail facility. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, you were given chances. And in this court, I don't know how other courts do it, but in this court, it is better to ask for permission than forgiveness. All you had to do was pick up the phone and call your probation officer and say, this is what's going on in my life. And if they did not address it, you know what you could have done? You could have come back to this court, come back to me, and I would have figured out what was going on. But for you to behave as though you were not on probation, that's a problem. You understand?
Yes, ma'am.
All right, good luck to you.
Garland Green appeared before a Texas court in case number 2023 CR 3544, where he faced a family-related assault charge. The state proceeded on the lesser included offense of assault causing bodily injury involving a married or cohabiting person, classified as a Class A misdemeanor. Green accepted a plea agreement and applied for deferred adjudication. During the hearing, the court reviewed Green's rights, the plea paperwork, and the evidence submitted by the state. The complainant had reportedly signed an affidavit declining prosecution and was described as uncooperative. After reviewing the evidence, the judge found sufficient evidence to support guilt, but deferred the adjudication. The judge was particularly concerned about the couple's young daughter, who had been present during the incident. According to the police report, Green and the complainant were arguing and throwing things around while the child witnessed the situation. Green's attorney requested that the court avoid a no-contact condition because the parents lived together and shared parenting responsibilities. The judge ultimately ordered 2 years of deferred adjudication, an affirmative family violence finding, 80 hours of community service, anger management, parenting classes, CPS compliance, regular probation reporting, testing, and field visits. Green was also prohibited from possessing weapons or ammunition. The judge strongly urged him to change his behavior for his daughter's future.